Good morning. Well, good afternoon, actually, we are now. Good to see you both. So welcome to Law 2020 Online, Civil Litigation, Shape the Debate with me, Emma Dion from the Solicitors Group, Helen Swaffield and Martin Langston. You both well?
Yes, doing well, thank you. Very well.
Great, let's get going. In this live session, delegates can put questions to Helen and Martin and interact as the information is being delivered. Today's live Q&A is due to last an hour and will cover your pre-submitted questions and live questions. To the right-hand side, there's a chat function. All questions are submitted in private, so please do ask away. And if you're watching a replay, the live chat function is disabled, but you may contact the Solicitors Group for further information. A recording of today's live session will be sent out by email within 48 hours, so please keep an eye out for that. So I'm going to introduce our speakers today. So first, Helen Swaffield, barrister and head of Contract Law Chambers. Helen has been a barrister for over 20 years and has worked in London and internationally before starting Contract Law Chambers at Chancery Lane. Currently, she's involved in large multi-party cases involving hundreds of claimants in the High Court. She's given seminars on contract and commercial subjects and litigation. And as part of Law 2020 Online, Helen's sessions included Part 36 and costs, interim applications, top 10 2020 cases and procedures, and damages and other remedies. And Martin Langston is a specialist business and property practitioner with experience in complex and high value claims. He's developed a busy and varied litigation practice, routinely appearing at the business and property courts throughout England and Wales. Martin acts for individuals, businesses, lenders, insurers and local authorities at interlocutory applications, injunctions, trials, appeal and ADR. So to kick off, we'll start addressing some of the pre-submitted questions we've been receiving from you. So the first question I think we were going to throw open to Martin. There seem to have been lots of CPR amendments coming out lately. What do they cover?
You're absolutely right. There have been lots of CPR sort of updates and amendments over the last few months. And I suppose notably some of the most significant ones have been to do with possession proceedings. So we've had the new Practice Direction 51Z, which has stayed all the possession proceedings, and this was back in March. And then that was extended in June, and it was extended again in August. But actually, just as of last week, Master of the Rolls has confirmed that that stay, as of the 20th of September, is now lifted. So there's a document which, if you're practicing and dealing with possession matters, is well worth the read. It's the overall arrangements for possession proceedings in England and Wales, and it sets out the priority of what will be dealt with kind of most urgently and how to get stuff rolling again. And most of the cases that will be dealt with most urgently will be things like antisocial behaviour, extreme rent arrears, although extreme rent arrears is only covering things that are over 12 months, or if you're a landlord with more than 25% of your income coming from rental, then 9 months, which is still a very long period of time. Illegal occupation from squatters, fraud, deception, unlawful subletting and abandonment, and some local authority stuff. So there is a relatively small list of stuff that will be given priority to begin with. But alongside that, there's the new Practice Direction 55C, and this is something that anybody that's involved in possession proceedings will need to read. It's not really something that I can do good justice to in sort of 2 lines, but there is a requirement for reactivation notices for all possession proceedings, and without those notices will include things like how coronavirus has impacted on tenants and the parties to proceedings, but without that, the cases just won't get relisted. So it's important that people have a look at that. There's also it's not really a CPR amendment, but there's the the new notice requirements under the Coronavirus Act. So you'll be aware that as of the Coronavirus Act 2020, Section 8 and Section 21 notices were initially made to be 3 months notice, and then as of the 29th of August, or I think it was dated July in Wales, those have actually now been extended. It's now Section 21 notice now needs 6 months notice, and Section 8 notices are now a sliding a range of dates between 2 weeks and 6 months, depending on the ground. And those changes will stay in place until March 2021. So that's quite a big change one way or another. We've got some new amendments. I mean, they're not particularly recent in the sense that they're not this year, but the new statement of truth for court-facing documents is now widely in practice. So, the fact stated in this document, I believe that I understand that proceedings for contempt of court may be brought against anyone who makes or causes to be made a false statement in a document verified by a statement of truth without an honest belief in its truth. So that's a new form of the statement of truth, which we just need to be careful to make sure that on pleadings and in witness statements is up to date. And there are a number of other smaller amendments, but probably the last two that I'll touch on. One is that actually pre-action correspondence has now been brought into the scope of documents which contempt proceedings can be brought for. So the old 3214, which deals with contemptible statements, and really the takeaway from this is just don't mislead. Don't make sure your clients realise, the lay clients realise that we can't deliberately mislead people be it in pre-action correspondence and particularly obviously in witness statement court documents. So the old 3214 said proceedings for contempt of court may be brought against a person if he makes or causes to be made a false statement in a document verified by a statement of truth without an honest belief in its truth. The new one, the new 3214 says proceedings for contempt of court may be brought against a person who makes or causes to be made a false statement in a document prepared in anticipation of or during proceedings verified by a statement of truth without an honest belief in its truth. So the scope of documents which are contemptible has been widened. That includes pre-action correspondence. The last CPR amendment that I will just touch on briefly is the whole thing of electronic bundling. There are various local protocols that have kind of been updated, and really the takeaway with this is only include that which is absolutely essential. And His Honour Judge Hodge QC in Manchester recently was giving some guidance on this in relation to the local protocol there. And he reminded us that that the essential can be defined as indispensable or important in the highest degree. And certainly my experience would be recently that the court is really hot on this, just to make sure that we are only including that which is absolutely essential, and really to the exclusion. And it can be tricky working out what is absolutely vitally essential, but less is more, certainly at the moment. The protocols, almost all of them include page numbers. It's really important that the page numbers at the bottom of the page, the bundle number, matches the electronic page number, because that there have been a number of points where that's been pointed out to be, in fact I had it recently where on appeal where the judge was very keen to make sure that the numbering matched, because otherwise it can be confusing. Bookmarks, it can be really helpful to bookmark the various sort of tabs. It's important though that there aren't so many bookmarks that it just becomes confusing. So and keeping them searchable. Almost all of the protocols indicate that the PDF should be searchable. So there are, obviously, depending on where you are, it's worth looking at the bundling requirements for whichever particular tribunal or court you're in front of, but certainly keep it to just that which is essential, page numbers that match the electronic pages, and bookmarks just for sort of essential tabs so they're just a highlight. By no means is that everything, but they're some of the highlights. Hopefully that helps. I'm
sure it will. There's quite a lot to take in there, isn't there? But we want to much shorter question next, which is, so when should I use Part 36?
Sure. Shall I take that one? Is that someone aimed at me? There we are, Martin. Yes. Hello, everybody. Welcome this afternoon. When should always? No, we should say a bit more. Always, especially if you're a claimant, because you won't get the money that you could possibly get in terms of costs if you don't. In fact, I think that given what we talked about in the Part 36 seminar, which was that it's really clear now, if you've equaled or beaten it, you get what I like to call the strictly for, which is 10 up to 10% of your interest on the judgment, up to 10% interest in addition to your standard interest, indemnity costs, and the prescribed percentage, which is another 10. So, you know, to get hold of the strictly for, you really do need to be able to have a Part 36 that you can just whip out of your bag and say, here's one I made earlier. And if you have a Part 36 that you can whip out of your bag, then what we have seen this year, and this is what the seminar is about on the online seminar, is don't take any rubbish from the court. Just say, I've been on Mrs. Swaffield's seminar, and there are so many cases which say, I want the lot. I'm not having some, and not, I'm having 10, 10, 10. Yeah, just go all strictly and you'll remember it. If you're the defendant, then I would think very carefully about making an offer. I know that means that you're putting your hand in the fire for costs. But if they accept it late, it's rather like a boomerang, you know, you sort of throw it out there and then it comes back around and hits them in the face, because the claimant thinks, we're sitting on a defendant's Part 36. We can always accept the defendant's Part 36 and the poor mugs will have to pay our costs. But the longer that goes on, the more they will have to pay your costs, because if the claimant wakes up and smells the coffee and goes, oh, well, it's not going so well, and then decides to cave in, then they'll have to pay your costs. Now, I know it's a close run thing between a Calder bank and a Part 36 as a defendant, I agree. But I do like that boomerang effect when suddenly it wallops the claimants in the back of the head when they realise that they owe you more than they are going to recover in damages for their clients. So, you know, again, I'd say always.
I think we will remember that answer with always and strictly. That's going to stick in the mind, isn't it, that one? Thank you for that. So the next question is, of the pre-submitted ones, is how useful is non-financial relief in a damages claim?
Is that one mine, actually, or yours?
Do you want to take that one, Helen?
Okay, and then you come in. This is why I think we went out of, yes, we've jumped the order. Sorry, it's me again, folks. Do you know what? Now you're going to, don't chat and poll in to see if I get the figures right. But if you know how expensive it is in court fees. But I have to say the best value relief I've ever got, and we get it a lot because we do contract stuff, is non-financial relief, which is something like, Martin might know it, he's Googling it now. It's something like 540 quid if you're in the High Court. Is it 320 or 380 if you're in the county court? Martin will know the exact figures. But it's a load less than the High Court or the county court fees for damages. And it's so worth the money, because you can get a declaration, you can get specific performance, you can get an order for relief, which is equivalent to an injunction. You could get an account. I've often got an account and still got the money, you know. So it's a legitimate form of really pushing a remedy to maximize the bang for your buck. So for 500 and something in the High Court and 300 and something in the County Court, non-financial relief is my top tip. You don't have to pay it if you've just got further and other relief, because that's just, you know, what I can think about at the time when I stand up and ask. But if you've got something in mind, like declare what the contract means, or just do it, in the words of Nike, or this idea of account to me for money you've had that I don't know about, that can make a really big difference to the result of a case. And you know, it's always worth thinking, actually, is it damages, or do I need something else as well? Martin, did we get those fees?
It is. It's £528 in the High Court, and it's only £308 in the County Court. So, and for that, obviously, that, as you say, that covers all sorts of things like, you know, an account, a declaration, specific performance, potentially all sorts of other useful and exciting remedies that fall out of it, or as opposed to what can be 5% of a damages claim, which can stack up considerably up to 10,000. So
bargain basement.
So okay, great, thank you both for that, and I'm going to leave it to you to write books yourselves as to who answers the next one, which is, would you recommend early nearly evaluation, and if so, in what types of cases?
I think it's early neutral, actually. We might have
neutral.
Yeah. I beg you. I think it's early neutral. The question should perhaps. I think the questioner meant that. E&E, Martin.
Well, I think. So sorry. Just let's have the question again. Early neutral evaluation, or.
And if so, would you recommend early neutral evaluation? And if so, in what types of cases?
I think it can be really, really helpful, particularly where you've got two, especially intransigent lay clients. I think it can really help break the logjam, where there are good points to be taken on both sides, but nonetheless, sometimes mediation doesn't work so well, just simply because lay clients are keen just to feel like they've been heard. An early neutral evaluation, I think, can be really helpful in having a judge sit people down and say, well, there are good points here and there are good points here, and I'd probably go this way. And actually, at the end of the matter, as much as anything, the lay client can feel heard, and I think that's really useful, and that can be really helpful, and it can bring an end to things where ultimately you've got cases which are narrow. They could be determined on the toss of a coin. It could, you know, it's very fine one way and the other. And actually, really what people are looking for is actually the sense of feeling heard, the lay client, that is. And I think in those circumstances, that can be really, really helpful to sort of break through the logjam.
Okay, great. Actually, I've got a follow-up to that question, which is, can you explain the term early neutral evaluation?
So early neutral evaluation is where it's a bit like in family proceedings, where you have an FDR, judge-led. It's effectively like judge-led mediation. So you will sit down. It will be without prejudice. The judge that hears the early neutral evaluation will go through a little bit like in a mediation for both sides. They'll hear submissions from both sides, and they won't give a definitive outcome. It's not that they will make a judgment, but often the judge will say, well, there's these points and there's these points, and I would probably conclude it's slightly stronger on this side than that side, and this is probably what I might do. The judge will also help explain to the parties what it is that's actually, you know, they won't necessarily come up with a conclusion, but they'll point out, sometimes quite helpfully, these are the strengths of your cases and these are the weaknesses of your cases to both sides. So it's like a hearing in that sense. And as lawyers, we can kind of test run the argument, and the client gets to see, the lay client will get to see how it is that pans out and how that sounds in reality. but the judge that hears that, the papers that are on the file aren't retained with the court. The judge that hears it won't be involved in the case subsequently. And actually, as I say, it can be a really helpful way of moving things forward, where simply having a mediator isn't sufficient.
Okay, so it's a bit like a test run, and as you say, it can be useful when for claimants to get themselves heard and feel like they've had their say.
Or equally defendants, where sometimes an extra dose of reality is needed as to the strength or weakness of a particular case. Yeah.
Okay, great.
You have to be a member of the judiciary. You can have a judge, as anybody really. You can have, anybody can neutrally evaluate, so long as both parties agree, obviously. And as Martin said, it's not binding, but it's a jolly good test run. It's a jolly good test run.
Great. So next question. What is the most common problem you're seeing at the moment when you're litigating contractual disputes?
Shall I take that one? I think probably for me, one of the most common problems that I've seen in the last little while is a lack of attention to the formalities. And I think the takeaway from this one is pay attention to the formalities. So we had the case a couple of years ago of Briggs and Gleaves, which reminds us that there is no equity to rectify bad execution. And I think so many times recently I have seen this, where that just it's so easy to get the fundamentals wrong. So if we're thinking about executing something as a deed, have we marked that it is being executed as a deed, signed as a deed? If it's being witnessed, if it's being signed by an individual, is it being witnessed? If it's being executed by a company, have we got a director plus a witness? Have the basic formalities been complied with? Have we remembered that a witness can't be a party to the deed? Is it clear? And this one I've come across very regularly on some really surprisingly large contracts. Is it clear on its face that it's supposed to be a deed? And it's not. It won't be clear on its face that it's a deed simply because it won't be clear that it's a deed simply because it's been signed under seal. It's got to say on its face, this deed, it's got to use the word deed somewhere on the front page. It's got to be clear. And again, things like there's a rebuttable presumption of delivery for a company, not so for an individual. Have we completed the formalities in terms of just basically getting it executed correctly? And so I'd come back to it. I'd say pay attention to the formalities, get the simple stuff done well, because I think that's probably one of the most common problems I've come across certainly recently with contractual disputes. Is there anything you'd add to that, Helen?
Yeah, I mean, I think whenever I'm allergic to a few things, and one of the things I'm allergic to is terminating a contract. And I've acted for people who have been absolutely incompetent and hopeless. And we've still won because the other side have got really fed up with us and they've terminated the contract. But the contract was badly drafted and the termination was wrongful. And they didn't have the right to do that. And so we've been able to turn the tables and say, you're stuck with me. I'm doing my incompetent best, but you can't get rid of me. And what you've tried to do is to get rid of me in a way that you think is the right way, but it isn't. And I do love those zombie movies, don't you? Die and they go coming back, like as if they're kind of die and they come back again. And I always think that the problem is you just don't terminate a contract. Just don't do it. Drive the other side to do it, but don't do it yourself. And one of the big problems at the moment with the COVID epidemic is that people believe that they have the right to terminate because of COVID and the impact that that's had on all of us. When you really look at it, they don't. And I was chatting to a solicitor recently, and he said, well, they've tried to cancel the contract for COVID. They've tried to terminate it. And I said, well, but they failed because it doesn't say this in the contract. And I said, well, it's rather worse than that. It's not that the contract is still going. It's that they have wrongfully terminated. I've got somebody who served notice in a way that you shouldn't have served notice. You've wrongfully terminated. And then that gives you that right to go back against them for damages, even though one is the incompetent party. One is the one who's let everybody down, but you terminated and you didn't have the right to terminate. And that of itself gives that party the right to sue them for damages. So don't terminate. To drive the other side to it, but don't terminate. Stop delivering. Stop purchasing, but don't terminate.
Okay, thank you for that. Actually, this is another question on early evaluation, so we can just go back to that. How do you go about arranging for one, and is there a court form?
Ooh.
Good question. If I'm honest, the only ones I've come across tends to arise at directions hearings. I think because it's standard on certainly on some of the BPC standard directions, certainly out of Birmingham and in a couple of other places, and so it's included on the standard directions as to do you want a direction for early neutral evaluation. Other than that, I'm not actually aware of unless Helen might be. No, but I can't think of a form that you would fill in. I mean,
yeah. It's WP, so you shouldn't be. I mean, the fact it's like mediation, isn't it? The fact of it is in open, but you shouldn't be showing it off as it's without prejudice. So it's the same sort of alternative dispute resolution privilege as mediation. What goes on in Vegas stays in Vegas. Yeah. So I doubt that there'll be a form. I think it is directed by the court though. So early neutral evaluation will be directed as a matter of an order, and it's just a question of, I suppose, insofar as you might have a form, you could apply to the court for a direction for early neutral evaluation, but normally it will arise, or at least in my experience, it will arise or be queried at direction, sort of subsequent to DQs, the directions. If the question has missed that point, I think I would just get a stay, and you can just say for the purposes of ADR, get it all sorted, and then either file your Tomlin or crack back on. But get a consent order and faff around behind the scenes then.
Okay. Right. Going back to what we were talking about in between the early, the neutral evaluation, I've got a question on COVID, and it's so. Do you agree that force majeure can include COVID?
Martin.
Well, I think it's a really interesting question, and I think there's no generic answer. I mean, ultimately, every contract will turn on the terms of the contract. But what we are thinking about with COVID are things to do. I mean, generally, the question of COVID raises questions around things like frustration. So frustration will occur when we've got the contract's been entered into, and then there is a completely unforeseen event occurs, and that could, COVID could easily be that completely unforeseen event, and it makes the contract either physically or commercially impossible or illegal, and it transforms it into something that's radically different. So that's not something that anybody is going to be particularly shocked at. That's just the notion of frustration in contract. And the sorts of questions that we're then asking ourselves are ones of, was the frustrating event unforeseeable? or was the contract impossible to perform? Has the performance been made illegal? Is the performance of the contract, and again, we're radically different. And so if you've got a force majeure clause within a contract, it can be that actually that triggers, it may be that actually the framing, the interpretation of that clause means that actually COVID wasn't totally unforeseeable, because it depends on the framing of the clause. It depends on how that clause is worded, how it's framed. On the other hand, if you haven't got a well-encompassing, a very wide force majeure clause, it can be that actually sometimes it falls through that, and it actually just becomes that because the contract is radically different, frustration occurs, at which point actually the contract is ended. It terminates. It acts totally, and acts without the election of either party. So at which point the contract is at an end, and then it's a question of working out where we're going. So even if there is a force majeure clause within a contract, it's not always a given that actually it hasn't become frustrated. But as is ever the way, these things they're too specific to be able to give a generalized answer, really. So it falls to what is the scope of the clause, and specifically what is the set of circumstances. Is it, like, for example, is it a contract where you've got travel involved? Is time of the essence, and you're looking for a particular performance at a particular time, and actually you've got lockdown within that and you can't move? So you would have to look at it based on the facts and an interpretation of the contract, a construction of the clause.
Yeah,
So,
can I just add to that probably the answer is yes. I think probably the answer is yes, because even if you don't have coronavirus epidemic, pandemic, if you have something called an act of God, that is pretty much going to cover it, really. Or you have at the end of the clause, any other event beyond the control of the parties, that's going to cover it. So if I were a gambling one, I completely endorse what Martin has said. You've got to read, you've got to wrap it down, read it carefully. But if you're asking the question because it's not clear to you that it does include COVID, then look for act of God or any other cause beyond the control of the parties, a catch-all, and put it in there. The issue is probably not so much does it, I bet it does, but how long does it stop the contract for? And if you think of the force majeure clause as an umbrella, then there's going to be a point at which the brolly comes back down, telescopes back in, and put it back in the bag. So if you're at that point now where things are moving again, we're all working around it, this is the new normal, maybe you do have it as force majeure. But we looked at this in one of our seminars, the new case from the Court of Appeal called Classic Maritime. And I love this test. I'm ready, willing, and able to perform, but for COVID-19. And look at us here. Look at the Solicitors Group. We're here. We're doing it. We are ready, willing, and able to launch the conference, despite COVID-19 is not going to give you force majeure. Do you see what I mean? You've really got to get yourself right under that brolly. And if you can just do what we're all doing, which is keeping calm, and we're carrying on, then, you probably had it, but not anymore. You might have had it in Boris's big lockdown, but not anymore. And I do agree with Martin. If your client's got a wedding planned and they keep saying, oh, you can have it next Thursday in 2022 or something, that's cancelled, that's frustrated, that's gone. That no nonsense. No, it hasn't happened when I wanted it, when I invited everybody to come. This was a time sensitive contract. I was going on holiday or do you know, I live in Devon as well as in London. We have 3 P&O cruise ships in the bay. And I think what they're doing subliminally is saying, look at us, we're a cruise ship. Come on a cruise, because, you know, subliminally for all these people in Devon who are sort of watching the sea there, so that when life gets back into gear again, somewhere in their subconscious they'll think, oh, cruise. You know, I expect they'll go to Bournemouth next. Anyway, but yeah, I think, look, no nonsense. I agree with Martin. You know, it's frustration is difficult to use, but you know it if you've hit it. If the moment's passed, you know, and the holiday's gone, then that contract is frustrated. No nonsense.
Yeah, that's an interesting point you made as well at the end about possibly before in full lockdown, but maybe you know, things are changing, aren't they? So
I mean, you're an example of that, TSG, aren't you? You know, this is the conference, despite. Yes.
Right, COVID. Yeah, absolutely. I'm going to read out the next question. I'm not sure that it doesn't make that much sense to me, so I'm hoping it makes sense to you. I'm going to read it out as it's been put to me. So on terminating a contract, reasonable behaviour by terminating party doesn't enter into it, even with COVID.
On terminating a contract.
Well, if I just go insofar as reasonable behaviour, if the contract is frustrated, then frustration operates totally and without election. So reasonable behaviour is an irrelevance, because once it's frustrated, it's gone. But generally speaking, if it's not frustrated, then, and I'm not sure I've maybe fully understood the question, but if it's not frustrated, then we do need to think about our behaviour and whether or not it is reasonable, I think.
Okay.
There was a lovely singer. She's dead now. She was Whitney Houston, and she had a tune. Well, I won't sing it. It's all right. One Moment in Time. Can you hear it in your head? You know, and it was in that Bodyguard thing. Anyway, One Moment in Time. And I think what you've got to work out is when you measure the termination, that will be one moment in time. And the questioner is right. Anything after that point is too late.
Yeah.
If they've wrongfully terminated at that one moment in time when they terminate the contract, and if they've been unreasonable up to that point, making that termination wrongful, then reasonableness does come into it. But I agree, once they've terminated, you go, okay, I'll give up, you've terminated, I'm off now, I'll pick up my tools and go. It's over, it's done. You've had that one moment in time, and after that is too late. Whitney Houston.
Whitney. Yeah, perhaps if we've not or if I've not understood that question properly, the delegate can get back in touch and reframe it, and I'll put it to you both again. So next question. When should I use subject to contract, and is without prejudice enough?
Shall I take that one? So I think the takeaway point here is it's just really important to be crystal clear about what we are expecting to have happen next. Don't leave it to chance. So if it's going to be with a signature and there's going to be a signature on a piece of paper, I think it's important that we are clear about that. If it's going to be that there is a particular action is subject to client approval, then we need to be clear about it. If we're dealing with a company, it's subject to a board approval, then we should say so. And it's the takeaway here is just be crystal clear about what it is that needs to happen next. And as a side point, I suppose, I mean, I've come across a number of Tomlin orders recently, and it's important to remember that actually a Tomlin order is a contractual document. You know, you're compromising a claim based on a contract. You're contracting out, and don't leave interpretation to chance. You know, put everything in there. But in terms of subject to contract, I mean, there was a case very recently in Manchester where His Honour Judge Pearce was hearing a claim for specific performance, and it was a claim which it sends a shudder down your spine when you kind of think about it. But I think the case was Neoclis and Honor and Rees. And His Honour Judge Pearce, as I say, was dealing with this claim for specific performance, and the defence within the claim, it was a claim in relation to a contract of land, and the defence was there was no signature had been provided. So Section 2 of the Law of Property Miscellaneous Provisions Act requires that there's a signature, and a document incorporating a signature for contracts where there's disposition of land. And the question was whether a solicitor's signature, the signature block with the yours sincerely, kind regards name and was sufficient to be a signature for the purpose of a contract involving the disposition of land. And His Honour, looking at it, he said, looked at objectively, the presence of the name indicates a clear intention to associate oneself with the email, to authenticate it or to sign it. And in that case, what was actually held was that it was sufficient. It was sufficient to become a contract, because in that case the formalities had been met. And so, although it was without prejudice, and although it was subject to contract, it was sufficient to be a contract. Now, in that case, the solicitor was saying, well, no, actually, we're intending for there to be a signature on a bit of paper. And I think it was a couple of years ago, there was a Rosalina Investments and New Balance athletic shoes. Yeah, and there was it was in relation to one of the Man United players, and there'd been a previous contract, a 2016 contract. There was a new one which had been signed by one of the parties, but it wasn't. I think it had only been signed by one side, and the question in that matter was a question of whether or not, objectively looking through the communications, it was clear whether or not the parties had formed a concluded contract. And again, I would just come back to this point of be crystal clear about what it is that you're intending to happen next. So in that case, it was held that there was no objectively concluded agreement, and there were various things that were held as being significant factors. So there were in correspondence, it was saying, still needs Rosalina UK signature. We had things like in relation to executing the agreement. We have sending all the originals to the other side for counter signature. And in that particular case, they were talking about amendments and changes, not variations. Now, ultimately, there was a really significant point that actually Fellini had said he wouldn't make any more personal appearances until this agreement had been signed. And so it's just really important that we're really clear in our correspondence about what is it that needs to happen next. Where are we up to? Because it's easy to look back on things and go, oh, I didn't really mean that. But yeah, it's just really important to be clear.
I think there are different, aren't they? Without prejudice just puts it behind the curtain, and subject to contract stops being a contract, really. So one doesn't replace the other. You need both. There was a case this 2 weeks ago where solicitor got into a mediation with a litigant in person, which is very difficult to achieve, isn't it? And I was asked to advise, as we often are, as to whether what they did was a contract or not, whether they reached agreement. And they had reached agreement, but then she'd gone to see a solicitor and changed her mind. But we couldn't pin it to her. And I think that was probably because, you do have to, as Martin says, you've got to try and sort it all out at the mediation. And the mediator said, this person's they're in person, they don't have a lawyer. I must let them get advice. Well, if you're not, are you? You're not there yet. You're still working on a subject to basis. So she got advice. She didn't like what she'd done. She rode her back. Nothing we could do. Actually,
just picking up on mediation, we've had a question in. how much involvement have you had in online mediations as a result of the current situation, the pandemic, and any general observations regards pros and cons?
Love it. I'm never going to in person ever again.
I agree.
After a while, sitting still. Fantastic. Nobody has to move, and actually from a drafting perspective, I like the fact that I did quite a complicated. I mean, a lot of our stuff is quite complicated, and we were there for 18 hours. I have to say, my back the next day since I'd done the garden. But you can get a document going back and forth while the mediator, you can copy. So you've got the email going, you've got WhatsApp going with your little group, because you never know who's listening in. And great. And it was a very complicated agreement, which I would never have attempted to have done if we were in a hotel room or in a conference center or something. But because we were online, one could draft, send it over, get the version back, draft again, send it over. And that's all it was a kind of 5 or 6 hour drafting session. Now the client's got a bit bored, but they can go and have a cup of tea, can't they? You can put a little thing up saying back soon, gone for tea. Great.
I agree. It's worked. I think things being online has worked really well. I mean, it's more from a practical point of view, from my point of view, because as Helen says, you can be in one place. I found it actually works really well. But it is important to have the video, to have the facility, the technical facilities set up, and just to be clear with just knowing when the video camera's on, when who's tight, and having a private space within, that's separate usually to the mediation, so that you can communicate. I mean, I suppose that comes down to a little bit of just good kind of home working tips generally, really, insofar as I think having certainly for the remote hearings that I've done, I find it worked really well having a separate system, so that the lay client or the solicitor can pass notes, virtually speaking, or kind of talk to you while stuff's going on, so that they feel like they're still in control of what's going on, even though there's physical distance in the mix of it. But
yeah, so I think really saying, if you've got the tech, it's a thumbs up to online.
Definitely.
Keeping it topical, next question: what do you see the growth areas that are likely to arise as a result of COVID?
I would throw my tuppence in and say, I think the whole issue, the whole issue that we were just talking about in terms of the force majeure clauses and frustration of contracts, I think there's there is a growing swell. I can't tell you how many inquiries we've had and how many matters have come through, which are really, I mean, ultimately it comes down to a question of construction of contract, but really it's arising out of the question of, COVID has prevented this, that, or the other, and looking at, does this actually has it actually prevented it? Is it fully outside the scope of what was agreed? So the whole thing of frustration and COVID, and I mean, I was gonna say insolvency, but actually, if I'm honest, I'm not sure that insolvency actually will come up as, I think in due course it will be, unfortunately, it will be a feature of the world as things evolve. But actually, I think in the next 12 months or so, we'll see a lot more cases coming forward with people litigating where they're effectively, the expectation of what they were hoping for hasn't come about, and there's a question of what does the contract say about this? What right do I have? What do we need to do next? So I think that would be my tuppence worth for where is the growth.
Just moving aside from the contract side of things, which is where we come from, but just in general litigation terms, we are seeing defendants disappearing because they haven't got any money, and now the choice is easier. Do I just kind of pull a plug and just disappear into insolvency, and that's it? We're seeing that, and I always feel that the security for costs application is unfortunately only against the claimant, and it ought to be the other way around, really. But it's a very difficult decision. You have to call it with your client. I mean, I sent somebody away and I said, look, this is a jobbing building company. The minute you issue, he will liquidate it. You know, that it was almost a boast on the other side. Come on then, come on. I'll just pull the plug. And getting people into costly litigation without recoverability is a bad scene, really. You know, but it's picking your battles, isn't it? The other thing I think people will do is they will enforce what is owed to them, whether it's a will or a possibility of a will or some sort of testamentary benefit, or it's debt, it's old debt, or they'll pick over the bones. We're seeing a lot of, you know, the kind of liquidator litigation where it's no win, no fee if they can get some money off a director, or, you know, all that sort of thing. I think people will see what they can achieve. But the recoverability issue really concerns me. Going
I would agree with that. I would agree with that. There are an unfortunate groundswell of too many cases where you see it's a reasonable cause of action, but you have to sit down and say, where is this going? Is there going to be any money at the end of it?
Yeah, I think, as you say, it's about picking the battles, isn't it? Otherwise, you're not going to end up with anything at the end of it all. So time for just a couple more questions, probably. Next one is, I heard there are some changes to the disclosure pilot.
Oh, yeah. Yes, we're all suffering, aren't we, with the disclosure pilot? A good place to look at those changes, I have to give it, is the Herbert Smith's website. They've got a good summary of the commercial court. That we did quite a lot of work on disclosure in one of our sessions. We're going to get a better definition of known adverse documents. We're going to murder clients who don't preserve documents much more successfully. And we're also going to make sure that we've got Model C under control, so that it's not an unending list that goes on and on and on, you know, like a lifetime questionnaire of, can I have your swimming certificates as well, please? And finally, the whole e-disclosure is going to be simpler. So it's going to be the same, but less than it was before. So that's good news, isn't it? But it's not going away, that DRD pilot, gang. It'll go to the county court as well, but they haven't told us when.
Okay. Martin, anything to add on that? Or
no, I would. That's the hopefully it doesn't come to the county court too soon.
Right. Well, I think that hour, well, the 55 minutes we're up to, is flown by, hasn't it? So unfortunately, that's all we've got time for today. Thank you for attending LAW2020 online. Civil litigation shaped the debate. Thank you to our expert speakers, Helen Swaffield and Martin Langston. Thank you both.
Thank you.
Great.
Thank you.
I'm going to take away, which is always for part 36, and I love the mention of Strictly and Whitney in the same hour. Loving that.
I think it dates us both, doesn't it? Well, you know, I'll get on to the Spice Girls in a bit with "Tell me what you want, what you really, really want," which is another one, which is another good tip for litigators, isn't it, when dealing with their clients? But anyway, we must stop there.
We must stop there. So don't forget to join the Solicitors Group LAW2020 online community on LinkedIn to continue the debate after the live session and to be included in exclusive offers for next time. As I mentioned at the beginning, a recording of today's live Q&A will be sent out within 48 hours by email. There's still time to watch the pre-recorded content. The expiry date will be displayed next to the webinar, and feedback forms for the event will be sent out when the event closes. And by completing this, you will receive your CPD certificate. Please don't forget to visit the online exhibition at www.thesolicitorsgroup.co.uk. And by visiting that exhibition, you can access a free 1-hour CPD webinar from the 2020 Distance Learning Catalogue. We'll stay on for, I think that's it actually. I was going to say we will stay on for a couple of minutes, but we are up to time. And so thank you again, and I hope you all have a great day.
Bye-bye all. Bye.
See you soon.